Thank you. My name is Greg Choate. I'm an attorney at Bradford Barthel. I've been around the defense business of work comp for 15 years, certified specialist for 15 years. And we're here today to talk about work comp, our favorite topic.
And I'm Josh Diggs, Director of Claims at Orion Risk Management. We're a full-service brokerage based in Newport Beach. And I sat in your seat for 14 years. I spent 14 years as a claims examiner, or with a couple of different levels, really. Everything from the clerk and mailroom guy up to eventually handling first aid claims, medical only claims, litigated claims, and spent time at State Fund, AIG, and Sedgwick before transitioning over to the broker side of things. And now my role is to advocate for the employer and work with the carrier, defense attorney, and all parties to make sure the claims moving smoothly and to obviously identify closures and reserve reductions whenever possible.
And so today the goal, we're going to provide information to adjusters that we hear from judges and employers on handling claims. Hopefully everybody will be more effective on handling the claims. So when a claim happens, there's immediate discovery issues that need to occur. The first one is the injury AOE, COE. And AOE, COE actually has different meanings. AOE means arising out of employment, and that means their complaints relate to their work-related duties. COE is the course of employment that the injury actually happened during the time and place of employment. And before I go on, if you do have questions, we are live. You can type in your questions. We're going to try to get to them as we go along. The mechanics of that is interesting, and we'll try to answer any questions that we can along the way. If not, we'll do it at the end. And if not at the end, we'll definitely email you a reply because we'll answer all your questions. So for the adjuster, investigating a claim, you need to ask questions on how and when the injury occurred and the location of the injury. The employer will provide you the information, but you still need to verify from an adjuster perspective that what the information you're getting is true and accurate. I recently had a case where we're within the 90-day period to accept or deny. I'm looking at all the documents. The 50/20 form had slip and fall causing a back injury at one city. The employee statement had a slip and fall injury with a back injury at another city, and the supervisor written statement had a slip and fall back injury at another city. So clearly the city was at issue. Two of the cities were not in the state of California, and so that begs the question, well, is there a potential defense that the injury is not covered under the policy? So a lot of behind the scenes work went on to determine if the injury actually happened in another state or here, and if it's not in this state, is coverage provided? So we were able to get that detailed information and deny the case, and we settled for a low amount. But even though you get some information, you need to verify, talk to the employer, talk to the employee, take a deposition and verify the information that you're getting. Another case I had is a car rental place where there was a car rental location. They were very successful. The location they had only had one driveway, so cars were being returned and checked out at one site using one driveway. That kind of slowed them down. Because they were successful, they bought another building and they were refurbishing the building. They told one of their car cleaning guys to go over and help the construction people at the new building right next door, and during the process of cleaning out that building, he was dragging a rug and injured his back. So the question again, the adjuster was very detail oriented and discovered that it really wasn't on site, it was next door, and went up the chain to determine if that is covered under their policy or not, and we were able to deny that case and settle it for a low amount. So it's really early on, the AOE, COE aspect really does need a separate look and determination, because everybody may agree a slip and fall happened and there's a back injury, but where did it happen, the time and place, is it in the course of employment? You still need to look at those individually. And even, again, trust your employer, but verify the information you're getting. So the next thing you look at is is the injury specific or cumulative trauma? That comes into play a lot, and it's important to know your policy coverage period. What dates does the policy cover? Which dates are good, which dates are bad? If the employer contacts you and sends you a DWC-1 form with a specific date of injury, let's say it's March 1, 2018, or even a CT claim that says it's March 1, 2017 to March 1, 2018, you still need to investigate if that information is correct. A lot of times during the deposition, they'll say that's when they went into HR. They had pain several days before. They may have even treated with their doctor before, hoping it would go away before reporting a specific injury, or a cumulative trauma. It happens earlier before. So your goal as the adjuster is to try to ask questions and determine a good date of injury, even on a specific. If the specific happened a week earlier and they just went in, if it happened on, if the DWC-1 form says March 1, 2018, but it actually happened a week earlier, and March 1 is just the date they went into HR, that could still be outside of your policy period. If it's outside of your policy period, you don't want to administer the claim. You want to immediately deny it and tell the employer to push it to the prior carrier. So it's that investigation early on to ask, when did the pain begin? Did you change any work duties? Have you seen a doctor? Have you missed work? And a lot of times on cumulative traumas, the injured worker will say, well, I don't know, it happened a couple months ago. I'm not exactly sure. A tip to use is to kind of reference dates everybody would know. Well, did you have that back pain before Christmas? Did you have that back pain before Thanksgiving? Did you have back pain at Halloween? And so those big life events will help trigger that employee say, oh yeah, you know what, I did have that back pain in Halloween. I took my kids out, and remember I couldn't carry their candy, so I did have back pain in Halloween. So that would be helpful. If your policy doesn't start until November, then you know there's a potential date of injury for a CT prior to your claim as a possible basis to deny.
There might be some contribution opportunities there as well that a carrier or an employer would like to explore, particularly if it was a different employer altogether.
And what we also see is a claim will start out as a specific injury and develop into a CT. There's both, that they had back pain over time, and there really was, they lifted one box that really aggravated it substantially to get medical treatment. And so, Josh, does an employer have any concern or input if an adjuster opens up a specific and a CT claim? So
as far as input, I don't think they have much in the way of input. Technically, if an attorney is filing an updated app, they're going to have to open a claim. But this brings up an interesting point that I get asked quite often as well, is if we have knowledge that there's now 2 claims, but the reality is that most or all of the exposure is going to be on one or the other, then there could potentially be a case to shutting one of those claims down. I'll give you an example. Let's say we've got a cumulative trauma claim that's litigated and multiple body parts. PQME report comes in and says there's industrial injury to all body parts, and it's all related to the cumulative trauma claim. Well, in that situation, I think we've now effectively determined that there isn't a specific date of injury, or there isn't any exposure tied to that specific injury. So I would make the case as an employer advocate that based on now the medical findings, that there is now, it would warrant closing that claim. And so that's something that I would push. And maybe the bigger picture behind the scenes is, I'm sure some examiners may have heard of the term XMOD. I know it's something that typically a claims advocate or a broker might throw around, in a claims review, and everybody may not quite understand what that is. But the XMOD, in short, is essentially a factor of risk that an employer kind of carries when they're shopping insurance. And so if you've got 2 claims that are outstanding, then it's almost as if you're getting double hit. Now, again, we understand that if there's legitimate potential exposure to each of those claims, then you have to carry reserves on it. But the point that I would make, and I often push for my employers is that if we've effectively determined that there is not exposure by way of a doctor's report or maybe a deposition testimony, then I would push for closure on that claim. And I think maybe also the fact that I was a prior examiner and kind of putting my examiner hat on, I can see the benefit of that as well, because we all know there's objective, ratios, closing ratios that every examiner has to hit every month and maybe year too. So if you're looking for a closure at the end of the month and you need to hit those numbers, then you might want to take a look at one of your companion files and see if there's an opportunity based on what I just outlined there for a potential closure.
Oh, that'd be great. And that's everyone's goal, is to close files. And I had a question on going back to the car wash claim. The supervisor did send the employer or the employee to do that job, and so the question is, how can we still deny that case? It goes up to what the insurance policy covers. There was a lot of behind-the-scene works with the insurance carrier to get someone to read the policy and determine what site specific is covered and what the employer policy, what they bought. And so our common interest with the employer is about 95% of the time we have the same goal. There's 5% of the time where we have different interest. And unfortunately, on that case, the interest varied, that the employer, the insurance carrier argued, did not have coverage for that injury in their policy that they purchased. And so for a legal basis, we denied it on that. And generally you could deny cases on factual, medical, or legal. So that was a pure legal denial that ultimately would have had to go to arbitration to decide if there is policy coverage, yes or no. But we were able to CNR it and resolve it for a low amount. So I hope that answers your question. So getting the employer file, it's very important for things to look at for us from a defense perspective, is the wages and sick time and vacation. The wages, what I typically see is that they'll get the last year wages, they'll total it up, average it out, and get the TD rate. Well, you also need to look in there, are there any pay raises? Because if there are pay raises, that needs to be accounted for in the current TD that you're paying, because you're paying lost wages. So they're losing wages at a higher pay rate than is calculated before that pay raise. And also, if they went from a new job, a supervisor job, had more responsibility where more pay comes in, you need to take that into account in the calculation so you pay the temporary disability accurately. What happens is, at the end of the day, at the MSC, AA will come in and say, hey guys, you paid TD at the wrong rate for 2 years. You owe me $5,000 more, and plus penalties and interest. And so looking at the wage statement, there was a pay raise. We may be on the hook for more. They're not going to say anything to the end because they are interested in getting a higher settlement. So get those wages early, look for pay increases, and calculate from there. Also, the sick time and vacation, that helps pin down the date of injury for cumulative traumas and when the problems really began. The applicant's attorneys don't really care where the benefits come from, if it's insurance company A or insurance company B. As long as somebody's providing benefits, they don't care. Our job as defense attorneys and adjusters, we do have to care on that issue and make sure we get the accurate date so that accurate carrier is providing the benefits. And that sick time and vacation time will help when you talk to the injured worker. Well, I see you have back pain. When did that happen? Did you lift a box on a specific day, or has it occurred over time? And that goes back to asking the questions, did it happen at Christmas, Thanksgiving, Halloween? You're trying to pinpoint when that happened to figure out, is it truly within my coverage or not? Just because they say, yeah, I have back pain, it's work related, I've had it for a while, I really urge you to do some more pinpoint investigation to see, did they ever miss time from work, or when that true date of injury occurred. And again, everybody should know, when to accept or deny a case, we have 90 days to accept or deny a case. Everybody should be familiar with Labor Code 5402. That states within 1 working day after an employee files a claim form, and that's the real legal trigger date is the claim form. For an alleged injury, the benefits will be provided until the date of liability is accepted or rejected, and where liability for medical treatment shall be limited to $10,000. So even during the delay periods, within the 90 days, you still have to provide the medical treatments. You can still submit it to UR, and it's limited to $10,000, but you do need to provide medical benefits. It's not, you can't say, well, we're investigating, we're not going to provide anything.
So one thing I would add to that, and again, this is maybe just me putting my examiner hat on, but in a situation where, let's say someone is not represented and there's a need to delay a claim, and we're going to investigate it and potentially use up to the 90 days. What I did as an examiner is I always try to put myself in the claimant or the injured worker's shoes. And so in that situation where there's a claim being delayed and they don't fully understand that they're not going to get paid, and let's say they're not currently working for the employer for whatever reason, either they can't accommodate mod duties, whatever the case is, what I always thought was a good practice was to inform them about EDD disability benefits and how to go about doing that, and letting them know that they should look into this because you're not going to get paid until we can make a compensability decision. And I found that by me sharing that often helped them to understand what the process was like, and rather than on the 14th day, get hit with a phone call saying, where's my paycheck? I need an attorney now. When you're able to explain that to them, then it definitely helped avoid litigation.
And so delaying a claim, even though you are on delay, you pay the TD, and you should work with the employer to try to see if there's a modified job they could do something. The statistics show an employee who goes to work gets better results, in the beginning, middle, or end. It also weeds out people trying to take advantage of the system.
And for me, I think the overarching sort of game plan on this and on the entire 4 or 5 bullet points that we've gone over so far is communication. When there's a litigated file or just a questionable, suspicious file, there's so many moving parts, and the employer has a story, and maybe we have a different version from the employee, and maybe there's some other details coming in from the prior records, things like this. When you can communicate with all parties, and what I often recommend is, leading up to a decision on the compensability standpoint, if you can coordinate a conference call with all parties and really just kind of flesh out the details, you can avoid a lot of angst, angry phone calls from employers, things like this, because, and I mentioned this to Greg earlier, but everyone can take bad news, but no one likes a surprise. And so if there's a claim that's on the fence as to whether or not it's accepted or denied, then if you can have a call and flesh out the details, an employer can understand when we're fighting an uphill battle and we're going to have to accept a claim. They may not like it, but I think they can understand it. What no employer likes to experience is a claim that they thought or they had expressed they wanted denied and then gets arbitrarily accepted. That can cause a lot of angst, that can cause a lot of friction between the examiner, the claims management team, the employer, and the carrier. So in order to best avoid those situations, I like to proactively engage all parties. Again, have a conference call, spend 20 minutes to hash out all the details, the pros and the cons, weak denials, strong denials, and that way everybody's on the same page moving forward, and there's an expectation as to what's going to happen the next few steps.
Yeah, I think that's a key. From a defense perspective, we're happy to have phone conferences and explain the distinction between why we have to pick something up or why we have to deny it. Because a lot of times my thought is thinking down to time of trial. What am I going to be arguing before a judge, and what evidence do I have to argue that? Because we have the 90 days to accept or deny. We need that evidence early on, and if sometimes there may be times where I don't feel comfortable saying, well, I don't think we have enough, or we need to get more medical. And so avoiding surprises is always good. And we're more than happy to have phone conversations at any time with the employer to keep them involved in the loop. And other discovery issues is get that index search of applicants' prior claims that they filed. That thing is a gold mine on prior claims and injuries. And we're always going to want those prior injuries. It helps us out with scheduling a QME, a depot, helps with causation and apportionment to decide accept or deny a case. So when you get that index, take that extra step and get those records right away, because we're going to eventually need them, so you should get them immediately.
And just as a tip on this one, if you're heading into a claims review and you're going through, the open claims that are going to be discussed, take a quick glance or refresh your memory on the ISO index and EDEX checks, because I'm sure that if it's a claim that's being questioned or there's some apportionment issue, someone's going to ask about those prior claims. And if we did have knowledge about it and nothing was done to obtain those records, so that's just a little tip heading into a claims review, just to kind of refresh on the ISO index and EDEX searches.
And those records could take 30 to 45 days to get. So within that 90 days done of the time to accept or deny. And in regards to scheduling a QME, I always lean towards requesting the panel QME list early, because once the injured worker has an attorney, they're going to request either a chiropractor or a pain management doctor, and we probably aren't going to like any of those doctors on there. So even in the delay status or accepted status, if you object and get that panel list, you are the one choosing the specialty area. If it's a spinal doctor, neurologist, whatever it is, it's avoiding what applicant's attorney wants. And that doesn't mean you need to schedule that QME right away. That panel list is good for 2 years, but you have it in your back pocket for your specialty area, and you're able to schedule it if you want to, even though it may cost $2,000 to $3,000 up front if the applicant does want to get that, and they're not MMI, and everybody knows they're not MMI because of the treatment, the conservative treatment hasn't gone out. You've locked it in for the specialty you want. Well, think of how many cases you have now where you're ready to settle, but you have a chiro panel QME. Would you be willing to pay $2,000 to $3,000 up front to get rid of that chiro QME? I think on most of the cases I know of, I would, because they usually come back a lot higher, are not MMI where their additional reevals occur. So I generally lean towards getting it early, since the panel is good for 2 years.
Yeah, and when you do receive that QME list, it's not all that uncommon for you to not recognize every name on that list. So when I was an examiner, I kind of leaned over to the people on each side of my cubicle and kind of asked, hey, have you heard this doctor? Who's good, who's not? So what I would, if you're in that situation and maybe it's a geographic area that you're not familiar with, or just again a list of doctors that you're not familiar with, I would reach out to a seasoned examiner in your office, or also feel free to shoot it out to the office. I mean, that was something that we did in our team. That anytime we got a panel, we would kind of blast it out to our team and just ask, hey, what's the feedback on these doctors? Have they flipped sides? I mean, I think we all kind of know the strengths and the weaknesses of some of these doctors, but when you can kind of get a general consensus, either who's good or who's not, then that can help you sort of make a decision in who to strike and who maybe you're looking to target for that exam.
Right, and we do that from defense. We do that all the time, because even though you may have 3 good doctors or 3 bad doctors, you want to know which is the worst one to cross out and which is the best one to keep. So even though you may know the doctors, we still send out emails to get that extra input on our cases. And we're happy to answer any questions on QME lists. And you also want to get a discovery issue of a deposition. What we do is, from a defense perspective, is try to pin down the mechanics of the injury and have them explain where the pain travels, the level, pain level, how often they have it, and try to get them to explain all their problems and complaints, because we submit that to the doctor, and the doctor will comment on whether they are anatomically accurate or not, and that helps weed out people that are playing the system. Although they may have a legitimate injury in the beginning, they may try to exaggerate at the end, not necessarily fraud, but just exaggerate and like staying home and getting paid 2/3 of their wages. So we try to pin them down, body parts, what hit the ground, when did the pain begin, how often. We're also trying to get prior injuries to match up with the index, and it's obviously a good day if they don't admit any injuries and there's a bunch in the index search, then obviously that gets referred out. We're also trying to pin down dates of injury for the specific or the CT. What we hear is an employee's had pain for 2 months, but they continue to do their usual and customary duties and went to the doctor. So the question goes, well, what's the date of injury? So what the legal standard for a date of injury for a cumulative trauma is Labor Code Section 5412. The date of injury is knowledge, it's work-related, and disability. There has to be both. So even though they have continued to do their usual and customary job, they know their back pain is work-related, but if they continue to do their duties, there is no disability that triggers the date of injury. So you would want to find out at a deposition, or even the adjuster ask in the beginning, have you changed the way you do your job? You know, have you asked for help on lifting things? Did you change the way you do your keyboard? You know, do you take more breaks more often now? All of those could be used to argue that's the date of injury for a cumulative trauma. And that's kind of behind the scenes between insurance carriers. Those tidbits of facts is what we argue. I obviously argue the best one for my carrier and their policy, and the co-defendant argues the best facts for them to have pushed the CT in our policy. And it's really a factual issue for an arbitrator or judge to decide, but that's what you look for is knowledge is work-related and some disability that they've changed their job, missed work, called in sick, or used a vacation day. All that's factual. That's the nuances of the date of injury. That could be a presentation in itself, an hour-long nuance on how that goes, but generally you want to know when they knew it was work-related and have they missed any work and have any disability.
Yeah, and I've got a few things that I'd like to, kind of touch on this one as well, because in my opinion, the depot can really make or break a case, right? Whether we're going to have to end up accepting a claim because the applicant is just extremely credible, or if it's just going to strengthen the denial that we were making, and this guy's a terrible historian, and now there's potential for us to take to AOE, trial, maybe even fraud. And so, in my opinion, I like to over communicate heading into the deposition. So for one, be sure to notify the employer once you get the depot notice, and that's something that I recommend to defense attorneys and examiners, because the last thing we want to do is to notify an employer 2 days after the depot, oh, we had a terrible depot, or the depot was okay or strong. Why wasn't I aware of this? Why wasn't I notified? I would have liked to have been there. So I would recommend that as soon as you get a notice of a depot, send that off to the employer and then recommend they attend. But secondly, particularly if this is a claim that we're denying and potentially even taking to trial, again, with so many moving parts, I like to schedule a pre-depot conference call. I like to have a conference call with all parties and flush out all the details, make sure the defense attorney clearly understands all of our concerns, all of the employer's concerns, any hobbies, activities. Sometimes the employers have these little nuggets that that they don't fully understand, because again, we're examiners and defense attorneys, and we know how that information can help us leverage a settlement or change the way that we tailor questions. The employers don't always understand that, and so having that conference call helps them flesh out the details, and little things that they don't think can contribute would absolutely change the game plan that we would collectively have. And it just makes sure that we set that expectation for all parties, and that we're all in the same game plan. We all have the exact same strategy heading into this depot, that there is a strategy, rather than just kind of go through the motions. Where did you work? History, address, all sort of the typical sort of cookie cutter approach. When you can have a conference call in advance of this deposition, it's just going to allow everybody to kind of key in on the important things that we want to hone in on, and also any of the red flags and issues that we want to definitely focus on.
Right, and the phone conference with the employer is helpful to prepare for the depot, because you do get those tidbits of information because that employer contact is usually talks to their co-employees, and the co-employees know that guy the best. They've seen him Monday through Friday, 8 to 5. They know if he's into sports, athletics, did something recently happen, any car accidents or injuries. Those little diamonds in the rough are really helpful to the depot, because that sets up the questions to hopefully see if they're going to be honest and accurate on their medical history, or if they play any sports. And what I also get into is the wages. If there's any overtime or anything that they do on a regular basis, those little things are calculated into the temporary disability rate that should be paid. I actually had a case where, just think to yourself, how many people have had a bunkhouse rule come into play ever in their careers? I actually had one last year where this person in San Diego has 60, 70 acres, and they had their employees live on site and they didn't have to pay any rent. So that's hopefully a bunkhouse rule red flag. He doesn't live there anymore. Housing isn't provided anymore. So obviously, applicant attorney argued for an increased TD benefit on that. So all those overtime things, if it was going to be continuing, do have to come into play on temporary disability. So claims handling. See, let me change the slide here. You can see the guy there, he's buried in paperwork. Hopefully you guys are paperless or don't have that sitting on your desk where you're gonna drown in paperwork. But obviously you gotta submit RFAs to UR. Even if it's a denied case, you could issue a deferral notice. So if it's accepted later, you can submit it to UR to get an opinion at that time. Make sure that the AA and the PTP are getting their copies. If it's late, if there's a late UR, it's not the end of the day. AAs will argue that you still have to provide the treatment automatically. That is not the case whatsoever. What we would do is we would look at the UR decision. It'll cite the MTUS regulations. Is it reasonable and necessary for that treatment? And you still have that legal argument that, but for it being late, the treatment would have been denied, and it's not an automatic reason to provide the benefits. And also, if AA submits it to IMR, you got to look at that IMR. Even though it's rarely overturned, the 20% are overturned. So if it's overturned, look at the decision. Could even be partially overturned. If there's 5 items on there, maybe one thing got overturned. You got to really look at it closely, because if something's been overturned, you got to provide authorization for that one item.
And I'm gonna chime in here and kind of circle back to the utilization review piece about submitting RFAs to utilization review. Now, I understand and I realize that the best practice is to do that on every claim and every treatment request, but on certain circumstances or when certain things pop up, we're not necessarily required to do so. And I'll give you an example of when that might come into play. Let's say you get a call on a Friday afternoon from your employer, and there was a really bad accident. Someone slipped and fell. It was a fantastic worker. There's no issue at all that this injury occurred, and he's pretty messed up. He's limping, and we know that there's going to be a claim here, right? And we know there's going to be treatment. So when you go to you get the doctor's first report from Concentra, and it says 12 rounds of physical therapy. And again, this is just a general sort of example, but rather than have to send that off to UR and get up to 5 days for them to respond, in a situation where employers already called and made it clear that he's a great guy, we want to avoid him getting an attorney. In that situation, I would simply call up Concentra or US Health Works or whatever example I'm using, and say that's authorized. We know it's a legitimate injury, and there's no need for us to wait a day or two and up to 5 for us to authorize that. Again, I know it's not typically how we would do that, but on a case-by-case situation, I think it's important to understand the bigger picture, and that it's to take care of the employee. And if the employer has already made it clear, there's an admitted injury here, no issues, we want to treat this person effectively and quickly, then just know that in your examiner back pocket, you do have, and you should have, some authority to authorize that without having to send every single request. Now, if there's a broken tibia and there's a surgery request, then obviously that you want, typically surgery request, anything along those lines, you're going to want to send. But for a minor request like this, just something to consider that, you know, you can consider just approving that with the facility.
Right, and I agree that 100% of everything shouldn't be submitted. Obviously, common sense you should use in whatever TPA policy you have, but most of them, you know, the claims, you know, the injuries, you know, the conservative treatment. If you could save money and not submit them, definitely do that. And the same with IBRs. That's the new process now, and that's another hour presentation on IBRs. The thing you want to watch out for is the second request. Make sure they're timely. To have the service provider submit the second request timely. I'm actually have a case now where it's an admitted shoulder surgery that was submitted to IBR. The bill review came back requesting some additional detail on the procedures, some reports, and the CPT codes, but authorized a whopping 89 cents on the procedures. And so the adjuster paid 89 cents, sent out the notices, and the service provider has failed to submit the second request and information timely. They did submit it, it wasn't timely, so we're sticking to our 89 cent compensation, even though clearly there should be, had they submitted the information timely, there could have been some additional money. But again, watch out for those timely bill reviews, the second request, and if it comes back you do have to pay money, then pay that, look at it and pay that additional money. And for liens, the more objections you have, the earlier the better. If you get invoices that were denied UR for legal, medical, factual basis on the case, send out those letters. From a defense perspective, what I'm looking for at trial, I'd rather have 10 objection letters than 1 or 2. So feel free to, if you have a basis to deny, feel free to send out objections every time they request. And so now we're going to switch to the, let's see, the next slide is resolving claims. So preparing the settlement documents correctly. Obviously everybody prepares the settlement documents. You want to put the most accurate information in there. One of the questions that come up is, let me put Josh on the spot real quick, is when the defense is preparing defense settlement documents, should we include resignations? Does the employer care about resignations? Any thoughts there?
Yeah, so and that's a question that comes up often for us too. So I think that the key, before I address it, I think the key is to have a conversation with the employer. A lot of employers are leery about proceeding with a CNR when they're not going to voluntarily resign or no longer work for the company, because although this maybe it's not a typical occurrence, but it's not unheard of for someone to get hurt, that exact same body part, 2 days later, right? And so particularly if an attorney gets them, I'm sure everybody's heard sort of the horror stories there. And so in most situations, an employer, if they're going to pursue a compromise and release, they would like to have a voluntary resignation. I think we understand sort of the challenges that each carrier faces. They have best practices that factor into this. But from a general standpoint, most employers would prefer a compromise and release. And what that does on the back end, and when I was an examiner, I didn't always see after it's settled, and I kind of, obviously that was out of my window after that. But what the employers like to do is, if they're going to compromise and release a claim, CNR claim, on the back end, what it does is help tidy up any potential employment issues. It's sometimes we see wrongful termination issues pop up, wage and hour issues that pop up, and so if we settle a claim by a CNR, essentially you're losing all leverage. to wrap up all items nicely. And it's just a lot easier if someone's filing a wrongful termination claim against you, and then you've got a resignation notice that you can hand them to say, this is ridiculous, there isn't any merit here, you voluntarily resigned. And so, yeah, I think the short answer is yes, employers do prefer it. But the bigger picture is that I think it warrants a conversation in advance with your employer, just so everybody's on the same page.
Okay, and what I see in the stipulations that have the most opportunity to improve is the parts of body. When a stipulation, you're basically guaranteeing this person future medical care for life to that body part that you write down. So you always want to have the most accurate information, but also have it narrowly tailored as possible. So even though applicant attorney may have pled lower extremity, if the injury is really to the left knee, then you just want to put left knee in the stipulation and not lower extremity. And the same with the upper extremity. If it's pled as upper extremity, but it's really just the right wrist that was injured, limit it to the right wrist that you're going to guarantee benefits for life for medical treatment for this person. So look at what's pled, what you're putting in there to make sure that you really do want to provide medical benefits for life, because once it's signed and approved, it's done. And also in the stipulations, there's two different forms. One is for dates of injury prior to 1/1/13 or dates of injury after 1/1/13. And if you recall, from 2005 up through December 31, 2012, there's the 15% bump up or decrease for permanent disability if a job was offered. So the court has two separate stipulation forms to use. Make sure you're using the correct one, and make sure you're using the correct PD level if there's a bump up or bump down, and use the right charts to get the most accurate PD amount in there. And the stipulation on number 9 on page 7, that is an area where you could throw anything in there, including the kitchen sink, on what you want to stipulate to. We typically write in there that this resolves any and all TD, PD, penalties, mileage, serious and willful, 132A, wages, out-of-pocket expenses. Anything in there is kind of a catch-all that we want to resolve and make sure there's no outstanding issues that AA or the injured worker could come back to and argue for more benefits.
And you definitely want to just do a quick flyby of any CT claims as well for settling a specific claim, and there might be a couple of 1 or 2 companion files. I've seen it before where we forget to add those other claim numbers or those other ADJ numbers. So I would, anytime we're going to settle a claim, just make a mental note to make sure that you're resolving all claims, and specifically outline those as well, the claim numbers and ADJ numbers. Right,
and that box number 9 on page 7 is the area that you would put claim number X or ADG number X is dismissed with prejudice if we can, typically without prejudice, per whatever report, because the medical does come back occasionally. They've pled a specific and a CT, and the doctor says, well, everything is the CT. I don't think that specific day he lifted up the box and increased the pain was a true aggravation that gives rise to a separate date of injury. Everything is really the CT. So now what do you do with that specific? You would just have the stipulation to the CT that's going to provide future medical care, and in that box or other area, put in that this ADJ number, claim number, is dismissed with prejudice based on the medical evidence. So you do always want to include all dates of injuries and all claim numbers in your settlement document so they can't come back and haunt you. And even if there is a claim number with no ADJ number, your defense attorney should go to the clerk, submit your paperwork, and they'll create an ADG number so that the award or order specifically identifies that claim number as an ADJ number that's had some action taken on it as dismissed or approved, as whatever the case may be. And for the CNRs, this is the reverse of the award, where you want to be expansive as possible. If it's a knee injury, you put knee and lower extremity. If it's a hand injury, put the hand and upper extremity. Here's where you want to be expansive as possible And again, the same, it's section 9 on page 7. It's the same on this one, is where you kind of do your catch-all to include and resolve TD, PD, penalties, mileage, wages, out-of-pocket, etc. And typically addendums are used. That is another area you could add anything under the sun. And again, applicant attorneys and applicant, they're more focused on the dollar amount of the award versus the specific language that everyone's using. And
they just want their 15%.
Right. And that's where you would also want to protect the employer to include any 132A and serious and willful. Out of courtesy, we typically add that language in there even if one's not pled. And so now, how can you get PD credit using both parties? So what typically happens, you occasionally hear of a CNR being approved, the PD amount in there is incorrect. Everyone is in a panic because someone's gonna have to pay some additional money. You may call up AA and say, hey, unfortunately, out of our $50,000 settlement, I wrote $10,000 PD credits. It's actually $15,000. How about we both go down there and get a changed award, and I'll buy you lunch. I'll be more than happy to buy you lunch if we both go down there. Clearly, AA is not going to buy it. He's going to say, sorry, you guys prepped the CNR. It's on you. I'm not going to give you that extra $15,000 credit. You wrote $10,000. You're stuck with $10,000. And if you go to the judge is basically going to say the same thing, because it's from a legal perspective, it's a legal argument that it's a unilateral mistake. The person that drafted the document is kind of stuck with what they drafted. So mutual mistakes are fixable. So the question is, how can you change a unilateral mistake into a mutual mistake? Well, if you use the term both parties, I think that gives you a stronger argument that it's a mutual mistake. So looking at a settlement of $50,000 where you wrote in a $10,000 PD credit that's actually $15,000. And that typically happens if there's multiple claims, or you gave an award, or a TPA took over another TPA's claim, and for whatever reason the number was put down wrong. If you draft the document that both parties agree defense will get credit for all PDAs paid to applicant, and you could go further and say both parties believe $10,000 has been paid on this case. So now when that gets submitted and approved by a judge, and then later you notice, oh my gosh, I should have put $15,000 on there. I forgot to look at the CT claim. We paid a PDA advance on that CT claim of $5,000. Now the document, if you look at the document, well, both parties have agreed to get full PD credit. Both parties believe it was $10,000, but in fact, it's now $15,000. Now, if you call AA and he's not agreeable, you could go to the judge and you have a legal argument that it's a mutual mistake. Your Honor, the document as drafted says both parties believe it's $10,000, and in fact, it's not. Both parties agreed to get full PD credit, and I'm not getting it. So it's a mutual mistake, Your Honor. Can you please do an amended order? And it's ultimately up to the judge, but I think you are in a lot better legal position by using both parties. And you could use that term for anything in the document that you may want to protect yourself for, dates of injury and parts of body. If you say both parties believe no other dates of injury or parts of body exist that aren't settled outside of this document, well, if, for whatever reason you forgot to list ankle or internal or psych, if you look at the document that written and both parties believe all injuries are resolved in this document, then it's a mutual mistake. It's not a unilateral mistake that one party drafted, because it specifically, explicitly states in there both parties believe something. And so with that, that gives you a legal out. I've seen a lot where they'll put $10,000 subject to proof. That's okay, but it does, I think that's 90% okay. It still gives AA the argument that, well, I knew that was wrong. I knew it was $15,000. It's still a unilateral mistake, subject to proof. That's it's a unilateral mistake. They still drafted it incorrectly. I knew it, and so it's unilateral, Your Honor. Please don't do any amendment to it. So subject to proof is good, but I don't think it gets you out of jail as often as using the term both parties. So that's what I would recommend, is using both parties when you draft things to give you an extra card, extra legal argument if applicant attorney isn't a nice guy and willing to help you out on $5,000. Because again, I think applicant attorney and applicant really only look at the dollar amount that they're getting. He's concerned about his fee. Our applicant's worried about what check is going to be issued. The next item on there is the voucher. When can the voucher be resolved? Well, the voucher changed January 1, 2013 that we cannot buy it out, but there's still option in the settlement documents to resolve it. If the employee has returned to work for the same employer, the employer should have filled out that written modified job offer that would allow you to have a trigger that you don't have to pay that voucher. Also, if the PTP or QME indicates there is no permanent disability, then there is no trigger to offer that voucher after 1/1/13. For the orders, for compromise notice and orders, the judges have a box to mark whether or not the voucher is being resolved or not. I recently had a case where it was after 1/1/13. I marked the box that the voucher is being resolved because we settled on the PTP. PTP said no permanent disability. They returned back to work. We weren't on the hook anymore, so it was a new insurance carrier, so we did a CNR, and I marked that the voucher was resolved. The judge wasn't happy with that. The judge said, oh, it's only, look at the date of injury, you can't do that, and I crossed it out. And I said, okay, but even though it's not specifically in the order, we're protected because the document indicates that the PTP said no PD, and that supports in the labor code that there has to be a trigger of permanent disability for the voucher. So that allows our client to close their file right now and not have to wait for applicant attorney or applicant to request a voucher. And you're still protected. So the last item we have is WCB orders, WCAB orders. Obviously, if there's an order, you have to comply with it. If it's an order to pay, provide, or authorize something, provide information, and it's an order, you have to timely comply. It may not be right, it may not have any common sense, it may not be reasonable, but you have limited options on the order. If you want to fight it, you can either do a petition to remove or appeal it. And there's a lot of nuances, which one is the most accurate to do, whether to remove the judge or appeal an order. That's another hour subject on which one to do when. So clearly run it by your claims manager or defense attorney that you have. If you want to fight one of the orders that have been given out, what's your best remedy and procedure to do.
And one thing I would share here with regard to an order from the judge is absolutely documented, and that's obvious, right? But the reason, or when this can come into play, is we know just in this industry, reshuffling of caseloads, and if, for instance, an examiner is coming on to 40, 50 new claims, it's tough to kind of dig into 50, 40 new claims. So if you're able to, in the action plan or the status update, I put in asterisks and even in all caps if you want, but just make it abundantly clear for the next person that would handle your claim, or even for the supervisor team, is that this is the order, need to pay PD as follows, or authorize treatment as as the order is outlined. But if you do that, then you could potentially cause someone other than yourself some big headaches down the road, and maybe even sanctions, and you want to avoid that at all costs.
Okay, and we have here our contact information. I'm sorry we didn't get to all of the questions along the way. We will email you your answers to your questions, or feel free to contact us directly. Here's information for Josh and me. Thank you for attending or listening in on our presentation today, and we're going to turn it back to Tammy to finalize it.